Honorable Speaker, esteemed members of this House, my name is Eric Murioki. I am privileged to appear before you once again. I represent the County Assembly of Isiolo. Honorable Speaker, esteemed members, to continue with our submissions where my colleague has left off, the question that should seize this House, and Honorable Speaker, when you go to make your determination, is this: on a balance of conveniences, what ought to happen? We submit that this House ought to proceed with these proceedings because, as has been held in numerous court decisions, the governor will have the opportunity to challenge these proceedings in court. However, neither the court nor this House can freeze the statutory and constitutional timelines that are set for impeachment proceedings. So, Honorable Speaker, allowing the PO in the way that the governor's team asks this House to do would irreparably prejudice the Assembly, because there is a chance for the governor to challenge these proceedings, but there is no chance for the Assembly to reinstate or to pause this process and then come back. The proper time to question the validity of impeachment proceedings, as has been ably submitted by my senior Nyamodi, is after the process is complete. And Honorable Speaker and members, this is what the court held in the case of Kawira Mwangaza versus the County Assembly of Meru. Honorable Speaker, this position was also buttressed or had earlier been held in the Justice Kariuki Mate matter. Honorable Speaker, allow me to read an excerpt from the decision of the Court of Appeal, that is Mwangaza versus County Assembly of Meru and another, 2023 KECA. We observe that the applicant's right to be heard and to defend herself from the allegations made against her in the impeachment debate at the County Assembly of Meru provided under the standing orders of the County Assembly. If she is impeached, and emphasis on this part, Honorable Speaker, she will have another opportunity to present her case before the Senate during the hearing of the impeachment motion. Further emphasis here, Honorable Speaker, even after the Senate makes its decision, the applicant still has the avenue of petitioning the court for an appropriate relief if the decisions were to go against her. We are therefore of the considered view that the applicant's right to be heard will not be circumscribed. Enough said, this court lacks jurisdiction to consider the application before it for the reasons stated in the ruling. That is the Court of Appeal, Honorable Senators speaking. The second question that this House and Mr. Speaker should ponder is, where is the public interest in this matter? In this matter of the PO. This is an important question. The impeachment process has commenced. The Supreme Court and the Court of Appeal have, in very clear and no uncertain terms, they have forbidden lower courts from granting the kind of orders that the governor has brought here today, saying that he wishes to rely on to scuttle these proceedings. And, honorable senators, even where such orders are issued, what does the Supreme Court say? It says that should those orders be issued in error, then the assembly, the county assembly, is entitled to not immediately comply with those orders. Honorable Speaker, these are not my words. These are the words of the Supreme Court itself in the Mutembei decision. Paragraph 95 of that decision, and it is found in page 8 of our submissions, where the Supreme Court says, it is our understanding that the exceptional circumstances of this case, with a complex scenario of justiciabilities from contrasted standpoints, would lend justification to the non-effectuation of contempt orders at the beginning, and consequently, we would accommodate the reality of their not having been immediate compliance as would otherwise be required. The Supreme Court is recognizing that sometimes court orders are issued in error, and where the effect of those orders is to encumber a House of Parliament, a legislative house, from performing its duties, the Supreme Court is accommodating the reality that those orders do not have to be immediately complied with. Your honorable senators, on this basis, we therefore submit that it is in the public interest that this House dismisses this PO and proceeds to hearing, bearing in mind what the Supreme Court has said, what the Court of Appeal has said. Honorable senators, another issue I want to touch on is the issue of forgery that has been alleged in the governor's preliminary objection. And the only submission I will add to what my colleagues have said on that issue.
Counsel for the County Assembly.
Yes.
Just take your seat. I've got a communication to make. Now, honorable senators, ladies and gentlemen, the time now is 1 p.m. And in terms of our program, we are set out in the order paper. We are set to adjourn at this time. I note, however, that the County Assembly still has 10 minutes of their time. I therefore wish to invoke Standing Order 34-2 and 2A of the standing orders, which permit the Speaker, for the convenience of the Senate, to direct later interruption of the business for a period of not more than 15 minutes. I therefore direct that the County Assembly may utilize its remaining 10 minutes so that the Senate shall adjourn at 1:10 p.m. or such earlier time as the County Assembly concludes its submissions. The Senate then will resume sitting at 2:30 p.m. when the Governor's Council will have its 10 minutes to respond before the Senate proceeds to make a determination on the preliminary objection. It is so directed. Council, you may proceed to utilize your 10 minutes.
Thank you, Mr. Speaker, sir. As I was submitting, honorable senators, is that my colleagues have indeed said, and I agree completely, that forgery must be specifically pleaded and proven. The mere word of the Governor's Council on this pulpit cannot be taken as evidence of forgery. Indeed, in a decision of the Court of Appeal, Jennifer Nyambura Kamau versus Humphrey Bakanandi, the court held that it is also a settled law that fraudulent conduct must be distinctly alleged and distinctly proved. It is not allowable to leave fraud to be inferred from the facts. An allegation of forgery is an issue of fraudulent conduct. Honorable Senators, you have been told that it is a preliminary issue whether there was a sitting and whether from that sitting threshold for impeachment was reached. Honorable Senators, this issue can only be determined after a conclusive hearing of these proceedings. The Governor's Council has stated that they will rely on the affidavit of the clerk, who is an employee of the County Assembly, to tell you that there was no sitting. Honorable Senators, as a matter of fair hearing, we must then be allowed to test the veracity of those averments by the clerk under oath through cross-examination. And for that reason, Honorable Senators, this issue cannot form the basis of a PO. Honorable Senators, from the locus classicus on POs of Mukisa Biscuits, as was again affirmed in the decision that we have quoted in our submissions of Ali Hassan Joho and another versus Suleiman Said Shaban, for a PO to succeed, it must be a pure point of law which is argued on the assumption that all the facts pleaded by the other side are correct. It cannot be raised if any fact has to be ascertained or if what is sought is the exercise of judicial discretion. And I would perhaps just amend that to also include quasi-judicial discretion, because this House now sits as a quasi-judicial body. So, Honorable Senators, that issue of whether there was a sitting is at length canvassed in both the County Assembly's documents and the Governor's responses. And for that reason, it therefore cannot form part of a preliminary objection. We shall be, of course, adducing evidence to show that there were sittings of the Assembly on those 2 dates, even though there were attempts to scuttle those sittings. Honorable Senators, as I conclude my submissions, we shall lead evidence at the opportune time to show that there was vandalism at the offices of the County Assembly and that the said vandalism was orchestrated by the Governor or at his direction. That is the evidence that we shall bring here. We shall also lead evidence, Honorable Senators, to show that there has been a pattern of attempts to scuttle these impeachment proceedings right from the start, and these attempts were made by the Governor. We shall adduce evidence to show that the Governor took every possible step, whether legal or otherwise, to try and stop and scuttle these impeachment proceedings. For these reasons, Honorable Speaker and Honorable Members, we submit that it is necessary and this House ought to rule that that PO is untenable and that we proceed with hearing of the full case. My colleague will finalize our submissions. Thank you.
Honorable Speaker and members of the Senate, I'll just take a few minutes just to